Good morning, everyone. The time is 9 a.m. This is the first microphone check for captions. Microphone check 1, 2, 3. Microphone check 1, 2, 3. Thank you. Good morning, everyone. Time is 9:15. This is the second test for captions. Microphone check 1 2 3. Microphone check 1 2 3. As a kind reminder to those in the room, if you need to speak into the microphone at the podium, please push the mute button and adjust the mic according. And when you walk away, go ahead and tap the mute button once again. Thank you.
Commission on Environmental Quality to order. Today is Wednesday, October 25th, 2023. The time is 9:31 in the morning. With us today are Commissioners Emily Lindley, joining us virtually, Commissioner Bobby Janeka. Good morning, Commissioner. Can you hear me? Somewhat virtually. We see you, Commissioner. Well, we've got a quorum at any rate, and we'll check back with Commissioner Janeka in a little bit. We're also joined by our General Counsel, Mary Smith. I'm John Neerman. I'd like to begin with a few admonitions for those who are joining us virtually. Other than Commissioner Janeka, this doesn't apply to him, but for the rest of you joining us virtually, please keep your microphones muted when you're not speaking. For those who are making presentations, please wait to begin your presentation until our General Counsel or I have asked you to begin speaking. On items where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov. Include your name, your affiliation, and the item that you'd like to speak to, and we will do our best to accommodate that request. We have a very full agenda today, but before we get started, I'd ask just a little bit of grace to handle a TCEQ family matter, and that is that I want to recognize Tracy Miller for her 35 years of public service. Most of it with TCEQ, nearly all of it, I should say, with TCEQ or TCEQ's predecessors. Tracy came to the agency with a finance degree from the University of Texas and put that to very good use in our Office of Compliance and Enforcement, in our executive management team, and most recently on our Sunset Review team. And Tracy, we very much appreciate your contributions. They've been invaluable. I'll also add that Tracy has many interests and many talents, among them baking, and I've been fortunate to be on the receiving end of that. And if you ever get your mitts on a Tracy Miller cake, you are very fortunate indeed. I could go on, but I won't. I want to allow my colleagues an opportunity to say a few words.
Yeah, I could talk a lot about Tracy as well and her baking skills. First, welcome to your husband. That's so nice that he was able to join you today as well. Thank you for letting Tracy be with us as long as she has been. I don't know, Tracy's just fantastic, always has been. I think it was an IGR days for me a long time ago. I bet it was either her or Susan Johnson. I was always having to call one of them. She's nodding like, you did call a lot. And I would call them and say, I don't even think this is an OCE problem, but I don't know who in the agency to call. I don't know how many times I asked that to Tracy, and she would tell me who, even if it had nothing to do with what her job was at the agency. She's just a wealth of information and is so kind and such a good person. So congrats. Thanks for coming here today and joining us. A little bit of a trek. But yeah, this is awesome. I'm glad we get to recognize you and see you in the hubby.
Thank you, Commissioner. Commissioner Janeka, good morning. I don't know if you want to pile on to that. And we can see you, but we can't hear you. I think you can hear us. Yes. All right, we're getting closer. All right, sign language. I might interpret the sign language. Thumbs up. All right, thumbs up. All right. Tracy, the commissioners have all weighed in. I have a few goodies for you, if you'll be so.
1, 2, 3.
Here we go. We got you.
Can you hear me?
Yes.
Thanks. Congratulations, Tracy. Wish I could be there in person.
Thank you, Commissioner. Tracy, as I started to say, I've got some goodies for you if you want to meet me at the podium. I have a presentation to make. All right, thank you all for indulging that family moment, and thanks everybody for being with us today. Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision, supplemental proposal for decision, and proposed order concerning the application by Diamondback Recycling and Sanitary Landfill LP for new MSW landfill permit number 2404. The applicant will go first, followed by the protestants, and then the ED. Parties will have the following oral argument time limits: applicant 7 minutes, protestants 7 minutes collectively, ED 5 minutes, and OPIC 5 minutes. The applicant may save time for rebuttal as it bears the burden of proof on this application. So I guess we'll begin with the applicant. I believe Mr. Woodward is here for them.
Good morning, sir. I'll ask you just to double check that mic and make sure you've got a green light, and then you can introduce yourself, and the floor is yours.
Good morning. My name is Michael Woodward. I am with the law firm of Hant Scarborough. I have co-counsel with me today, Barton Haney and Trey Wasdorf, are both with Hant Scarborough. Also with us today are the owners, investors in Diamondback. I have Michael and Esme Valenzuela and their children, Mike and Marisa, all from Odessa, Texas. And their partner, Tony Underwood, is also here. We're also joined by the engineer of record, Mr. Todd Stiggins, and his partner, Holly Holder, of the engineering firm Park Hill out of Lubbock, Texas. As you may recall, we were here in December of 2022 to consider the first proposal for decision, which expressed concerns regarding the sufficiency of the surface water drainage report, which the commission decided to remand for the acceptance of additional evidence to make that determination. Even though the remand has added additional time, and it's been a long time for the Valenzuela family and the Underwoods, they started this process in 2016, and they are very grateful for the opportunity to address the remaining issue and clear up the record. I think I can safely say the record in this proceeding is now very clear. The surface water drainage report that was submitted with the application has shown to be more than sufficient and has demonstrated that the proposed facility will not adversely impact the existing drainage. The applicant's engineers properly evaluated the existing drainages through site visits, observations, and the use of engineering calculations in accordance with TCEQ regulations and guidance. The surface water drainage report accurately represents the flow patterns at the facility, the peak flow rates, the velocities, and the volumes of runoff that would occur from a 25-year, 24-hour storm at this location in western Ector County. To ensure that the runoff from the proposed facility will closely mimic that of the existing facilities or of existing conditions, the engineers designed a stormwater system to collect the stormwater, to convey it to storage ponds, and then to release it through broad-crested gabion weirs to closely mimic the overland flow of the existing conditions. To ensure that the runoff from the proposed landfill facility will mimic the existing conditions, the engineers designed that system to show that the runoff will flow across the eastern boundary, just like it does in existing conditions, that will meet the peak discharges estimated in existing conditions, will very closely mimic the volumes that are flowing under existing conditions, and most importantly, will leave the facility in non-erodible velocities through overland flow. That's the purpose of the gabion weir boxes, that it takes that flow and releases it in a slow manner and allows it to redistribute as it leaves the eastern boundary. Accordingly, the surface water
That's
drainage
4
report.
minutes.
Thank you. I want to save some time, but I do want to say a couple of things. The testimony in this remand was highly technical and very controverted by all parties. I want to compliment the administrative law judge, Megan Johnson, for her professional handling of the matter and her ability to present the issues in a much more understandable manner than what we sometimes heard from the engineers. It's a complex issue. But I'm happy to say at this point that the applicant supports the revised proposal for decision and respectfully request that this commission approve the application and grant the proposed permit. I'll reserve the rest of my time and stand available to answer any questions you might have.
Thank you, Mr. Woodward. I have no questions. Commissioner Lindley, any questions? Commissioner Janeka, anything for Mr. Woodward?
No, thank you.
All right. We'll give you an opportunity to offer a rebuttal in just a little bit.
Thank you.
Yeah, thank you, sir. So next we'll hear from the protestants. Ms. Perales, good morning.
Good morning. I'll be using my computer screen rather than a printout. So, my name's Marisa Perales, and I'm with the law firm of Perales, Allman and Ice, and I'm here on behalf of Mr. Jason Harrington and Knox Real Development LLC. Also, Mr. Mangle, who is also a protestant, has agreed to allow me to use the entire 7 minutes to present arguments on behalf of the protestants. So as you've heard, drainage concerns have been an issue regarding this proposed landfill since it was first noticed and since the comment period was first opened. Mr. Harrington commented about this issue from the very beginning before he had retained any consultants or any attorneys, and for good reason. He knows his land, he knows the area, and he knows what the issues really are here. Now, despite being put on notice of these issues early on, and despite having been provided clear guidance from the TCEQ regarding what the rules require and how to ensure that a landfill will not adversely impact existing drainage conditions, Diamondback elected to employ a novel approach to designing its detention ponds and an unreliable approach to determining what the existing conditions are at the site. As the PFD correctly notes, none of the testifying experts had used or seen the modified rational method used for a detention pond design for a 24-hour, 25-year storm event. Setting aside the detention pond designs for now, though, Diamondback's surface water drainage report suffered an even more fundamental flaw, one that affected the entire analysis from the beginning. And although surface water drainage analyses can be rather complicated, this fundamental flaw was not so complicated. And in case there was any question, the TCEQ has guidance documents to determine how to ensure that a proper analysis of the existing drainage conditions is done. Here, Diamondback never figured out its peak flow rates, its volume velocity for the water leaving the site under existing conditions at the specific discharge points that it used for its comparative analysis. It ignored the guidance document that has been used by landfill permit applicants for years for purposes of comparing existing to fully developed landfill conditions. This guidance document proposes a 5-step process for determining the existing conditions and then a repeat of that process to determine the fully developed conditions so that an apples-to-apples comparison can be done. The 5 steps start with determining the discharge points. In this case, Diamondback skipped that very first step. Because water leaves the site via overland flow, Diamondback didn't select any discharge points for its analysis. It just calculated a peak flow rate for the entire drainage area that it designated and assumed that that this peak flow rate exited the site at the points that it selected. Now, the second step requires calculation, as I said, of the peak flow rates for the discharge points, but as I mentioned, Diamondback only calculated a peak flow rate for the entire drainage area, and it didn't attempt to determine what portion of that peak flow rate actually exited the site at any of its designated discharge points. Under fully developed conditions, we know where water will be discharging from the site. That's how the landfill is designed, to detain water and allow it to leave at specific points. And then these points are supposed to be used for comparison purposes to the existing discharge points. And that just didn't happen here. If you don't know what the existing condition discharge point peak flow rates are, then you can't do an apples-to-apples comparison of those rates for the fully developed conditions. The commission allowed Diamondback a second bite at the apple to go back and present more evidence to demonstrate that it had nevertheless achieved the objective of the rules. And the objective of the rules, to be clear, is not about whether it used the correct rational method or made the correct calculation. The objective is to establish reliable baseline conditions that can then be compared to fully developed conditions. Diamondback squandered this opportunity. Instead, first it filed a frivolous petition in Ector County District Court seeking to depose my law partner and obtain confidential privileged information. Fortunately, that petition was denied, but it did require the expenditure and waste of resources. Diamondback then retained a professor who's never designed a detention pond at all before, certainly not for a landfill. Still, he was able to provide useful information about existing conditions, and that information established what we've been saying all along. If you look at the specific points where water is leaving the site and where it's proposed to leave the site, you'll see that peak flow rates are significantly less under existing conditions than they are under fully developed conditions. This was consistent with what Mr. Dunbar had testified to and estimated on behalf of the protestants. The Diamondback's chief engineer provided no further useful information regarding peak flow rates at its identified discharge points. Instead, he argued that there's a road that exists that might impact how water leaves the site, even though he never took into account the road in accounting for his own peak flow rates and calculations at all. Still to this very day, Diamondback's engineer cannot tell you what the peak flow rates are for existing conditions at its designated discharge points. Dr. Cleveland, their other expert, can. Mr. Dunbar can estimate it, and so can Mr. Saxon. All experts did estimate what those peak flow rates are at the existing conditions, and they came up with peak flow rates that are significantly less than what was estimated by the Diamondback's chief engineer and significantly less than what they are proposed to be under fully developed conditions. I'll quickly turn to the detention ponds, and that's actually, although that too can be a complicated issue, in this case it's rather simple. The rules and the guidance document requires the detention ponds be designed for a 25-year, 24-hour storm event. There's nothing in the application indicating what the volumes would be for a 24-hour, 25-year storm event. There was no additional evidence presented to show what those volumes would be for a 25-year, 24-hour storm event, not by any of the witnesses that were presented by Diamondback. Again, the rules are not about what method should be used or whether calculations using the method were properly done. The rules require a certain standard, 25-year, 24-hour storm design event to design those detention ponds, and that simply wasn't done.
Just ask you to finish your thought, Ms. Perales.
Sure. I would say that granting this application, where we don't have a 24-hour, 25-year storm event, granting this application would create new precedent, would require a change in your guidance documents, and possibly require a change to your rules. And again, the impacts here are not an academic exercise. The impacts will be borne by my client. Thank you.
Thank you, Ms. Perales. Colleagues, any questions for Ms. Perales? Seeing none. Thank you. We will hear next from the executive director's staff. Good morning.
Good morning, commissioners, general counsel, public interest counsel, and parties. I'm Anthony Tetu. I'm with the Environmental Law Division, and I have with me today Chandra Yadav from MSW Permits. The executive director respectfully recommends that the commission adopt the proposal for decision, which has been prepared by the administrative law judge. In this case, as has previously been mentioned, this application was remanded back to the State Office of Administrative Hearings in December of last year to take evidence on just one issue, which is whether the applicant provided a sufficient surface water drainage report. We did have a 3-day hearing in April of this year, and the administrative law judge concluded that the evidentiary record supports the issuance of the draft permit and recommends that the application be granted. The executive director agrees, and we're available for any questions you may have. Thank you.
Thank you, Mr. Tatu. I have none. Colleagues, any questions? Seeing none. Good morning, Ms. Mehta. What does the Office of Public Interest Counsel think?
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, Attorney, and staff. For the record, I'm Pranjal Mehta for the Office of Public Interest Counsel. OPIC respectfully disagrees with the administrative law judge's finding that the administrative record supports issuance of the draft permit. As it relates to peak flow, the crux of the dispute is whether applicant was required to calculate peak flow rates under existing conditions at specific discharge points along the permit boundary where the detention pond discharges would occur under the proposed conditions. The CQ rules and regulatory guidance stress the importance of characterizing existing drainage patterns as a baseline for comparing with the post-development drainage patterns to demonstrate that the existing drainage patterns will not adversely be altered. Therefore, accurate characterization of existing drainage patterns is crucial for establishing this baseline. Considering the evidentiary record, OPIC cannot find that the existing drainage patterns are accurately characterized. We do recognize that the applicant's expert, Mr. Stiggins, emphasized the significance of multiple hydrological factors and asserted that peak flows are just one element of the baseline conditions. However, OPIC insists that accurate baseline conditions, as mandated by TCEQ rules and guidance, must be diligently considered to ensure a thorough assessment. Regarding detention ponds, detention pond design and sizing are essential for preventing runoff and safeguarding the environment. The record shows that applicant's surface water drainage report fails to include the required storage volume for a 24-hour duration storm event as mandated by rules. The applicant's expert witness explained that he only included shorter storm durations because they have higher intensities. However, OPIC views TCEQ rules to require that the applicant guarantee that the detention ponds can effectively collect and control a 24-hour, 25-year storm event regardless of its intensity. This is a fundamental step in ensuring that existing drainage patterns are not adversely altered. Additionally, with specific regard to methodology used to predict estimated rainfall amounts during a storm event, OPIC was concerned that neither the EDs nor the applicant's experts had any previous experience with the modified rational method, the method utilized by the applicant. Further, OPIC found protestants' argument compelling that the applicant relied on a uniform rainfall distribution, despite the fact that a non-uniform rainfall distribution would achieve more accurate results. For these reasons, OPIC concludes that applicant has not provided a sufficient surface water drainage report, and because of applicant's failure to meet its burden of proof on issue M, OPIC respectfully recommends that the application be denied. Thank you, and I'm happy to answer any questions.
Thank you, Ms. Mehta. Colleagues, any questions for Public Interest Counsel? All right, seeing none. Mr. Woodward, you have 2 minutes and 15 seconds by my count for your rebuttal.
Thank you. Here's where we get into the complex nature of the matter. With respect to the existing conditions, everybody agrees that under existing conditions, this is western Ector County, relatively flat, water is leaving the property in an overland flow fashion, like this. There are no channels, there's no erosion occurring. And so the rational method does not calculate at a specific discharge point. The rational method calculates what the peak flow will be from the entire drainage. It uses a comparison point and uses what's called a time of concentration calculation to show when the entire watershed is contributing to the discharge. And that's very important because rainfall, a drainage area accepts the rainfall, and then it builds up and it starts to run off. And it's when you have the time of concentration equals the duration of the storm is when you're going to have peak flow. And that's then when it starts to trail off and the water continues to run. But at that moment, when you have the peak flow, that's what the modified rational method calculates. That's what was accomplished here, to say what the entire volume of the water is going off the eastern boundary. Well, when you build a collection system, you have to put in a system that's going to retain that amount to meet that peak flow. What was designed was a relatively wide discharge structure so that you're not creating a discharge point. You're trying to mimic that overland flow, which is what happened here. And so if you just go calculate a discharge point, you're ignoring all that other flow that's leaving the property through overland. And so you have to make sure that you're capturing the entire volume that's contributing to that peak flow. And that's what occurred here. Now, with the modified rational method, we heard testimony from a recognized expert out at Texas Tech University who's actually written a book on guidance document for the highway department, who commonly uses the modified rational method.
That's
And
time.
I'll ask you just to finish your thoughts, sir.
So the modified rational method is an accepted methodology to calculate the necessary volumes to assure that you're retaining enough water to meet the peak flow.
Thank you, sir.
Yes, sir.
Colleagues, any questions or comments? All right. Thank you, sir. So here's some of my thoughts. When we considered this item late last year and narrowed the issues to the surface water drainage issue, I shared my view that the protestants had not submitted sufficient evidence to justify permit denial, nor was I overwhelmed with the applicant's prima facie case, which is why we remanded the matter to take additional evidence. And given the ongoing discussion about burden of proof, I did want to begin simply by clarifying that a protesting party may rebut the prima facie case by presenting evidence that, quote, demonstrates the draft permit violates an applicable requirement. And I think this is important. The Texas Government Code, section 2003.047, I-2, subsection 2, uses that word demonstrates. So we need something more than just evidence. We need evidence that demonstrates a violation according to the statute. And then, of course, once that rebuttal evidence is presented, then the Government Code allows the applicant and the executive director to present additional evidence in reply to the rebuttal case. So now, colleagues, following remand, we do have sufficient evidence on the issue of whether the existing drainage patterns will be adversely altered, and the ALJ has weighed that evidence and determined that the applicant has met its burden. I come down the same way. I don't see a basis for overturning the ALJ. Concerning the calculation of peak flows, protestants urge the use of a variable rainfall distribution, but this is not required under the rational method, nor do I see a legal basis for imposing such a requirement. As for whether the applicant makes the appropriate comparison with respect to discharge points, the comparison of existing overland flow to post-development flow through weirs is consistent with TCEQ's surface water drainage guidance. And finally, the modified rational method has been applied appropriately to determine pond sizing, and I think the record evidence does show that the ponds are designed to accommodate the 25-year storm. So in short, I would adopt the proposal for decision and as has been supplemented on remand, and I would grant the application. I have one point of disagreement, however, with the ALJ, and that relates to transcript costs. The extent to which a party prevails on issues that have been referred to SOA is not a factor for allocating transcript costs. I think in lieu of what the ALJ proposed, a 50-50 split would be appropriate. So I would make those changes as well as a few clerical corrections to what's before us. And I am happy to read a motion if you all are aligned with those thoughts, but let me go next to your thoughts. Commissioner Lindley.
Well, I'm in agreement. I think you laid that out very well. I don't really have anything additional to add to the points you made. And, I'll let you read a motion. I think I'll probably likely agree, but I'll just leave it simple and leave it at that for now.
Thank you. Commissioner Janeka.
I too am in agreement, and the point on allocation of the transcript costs, I think, were well founded. That factor makes sense. It's reasonable, but there's no statutory or rule basis on it. I'm in agreement.
Thank you, Commissioner. All right, well, colleagues, let me offer a motion. I move that we adopt the ALJ's proposed order as amended by the ALJ in her June 16, 2023 supplemental proposal for decision following remand, including deleting proposed finding of fact numbers 63, 64, and 65, and conclusion of law numbers 16 and 22 from the original proposed order, adding the ALJ's new findings of fact and conclusions of law, and renumbering the findings of fact and conclusions of law in the order to accommodate the new findings and conclusions. In addition, I move that we make the following modifications to the proposed order. A, modify proposed ordering provision number 1 to indicate that the application is granted and that the Commission hereby issues MSW permit number 2404. B, modify finding of fact number 3 to state that the facility is located at 2301 South FM 866, Odessa, Ector County. C, correct the date of the NORI in finding of fact number 8 to read, quote, October 30, 2019, end quote, consistent with the evidentiary record. D, modify renumbered finding of fact number 42, which is former finding of fact number 36, to cross-reference finding of fact number 40 rather than finding of fact number 33 to accommodate renumbered findings of fact. E, delete renumbered finding of fact number 127, which is former finding of fact number 113, relating to prevailing issues, as it is not one of the factors that is considered by the Commission in evaluating the allocation of transcript costs in accordance with 30 Texas Administrative Code Section 80.23D. And F, modify renumbered finding of fact number 127, which is former finding of fact number 114, renumbered conclusion of law number 29, which is former conclusion of law number 25, and ordering provision number 2 to provide that the applicant must pay 50% of the transcript costs and Knox Harrington must pay 50% of the transcript costs, as the parties both benefited from the transcripts. I further move that we grant the permit application of Diamondback Recycling and Sanitary Landfill LP for MSW permit number 2404 and adopt the Executive Director's response to comments.
I'd second.
The motion has been made and seconded. All those in favor say aye.
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 Aye. The motion carries. Ms. Smith, when you're ready, I'll ask you to please call the next item.
Item number 2 is the consideration of the proposal for decision and proposed order concerning the petition for the creation of Highland Lakes Municipal Utility District Number 1 of Ellis County. The parties have been notified that the petitioner will have 10 minutes. The protestants will have 10 minutes, and the ED and OPIC will each have 5 minutes of oral argument time. That is also the order for oral argument. The petitioner should speak first and may reserve a portion of time for rebuttal as the petitioner bears the burden of proof in this matter. And I believe we have Ms. Scott for the petitioner.
Good morning, Ms. Scott.
Hi, good morning. Just for the record, my name is Natalie Scott. I'm here on behalf of the applicant petitioner in this matter. I'm proud to have my clients here with me along with my co-counsel, Kevin Bartz. And I've previously, I think, notified the clerk that I'd like to use 3 minutes for my initial presentation and reserve the remainder of my time. And I'd like to use my initial comments to sort of signpost where I'd like to go with this, but my client is here and pursuit of the highest and best use of the land that is located in Ellis County, Texas. And it is made the attempt to create a municipal utility district pursuant to the Texas Water Code through TCEQ regulations and through Texas public policy that is all supportive of the option for a landowner to create a development that is in a way that's affordable to the Texas home buying consumer. And we are here to challenge only 2 points of the PFD. The PFD the applicant met its burden in all respects. And the primary aspects that the commission considers in granting a municipal utility district or allowing its creation is whether or not the proposal is feasible, practicable, necessary, and a benefit to the land to be included in the district. We met that burden wholly at the SOA hearing. There are a number of other issues that the commission may consider when approving the creation of a MUD, and the commission did consider all of those issues, and this is standard with creation of any district, whether it's contested, uncontested, legislatively created, or not. Here, we're on obviously a contested creation, but the only 2 issues that the administrative law judge had issue with, and again, I want to focus on the word unreasonable, which is what is included in the statute. This is not a higher burden than any development would have to achieve, whether it's included within the boundaries of municipal utility district or not. But the 2 issues that the PFD took issue on the reasonableness were groundwater levels in the region and water quality. And I would point Chairman and Commissioners back to another agenda item that I was present on recently, where Chairman, you noted that the source of groundwater is not a factor for consideration with groundwater levels in the issue. The really only
That's 3 minutes.
Okay. Only issue we're left to is pervious cover in the region, and that on page 32 of the PFD did not have a concern with the recharge capability. The applicant provided evidence that the percentage of pervious cover was adequate and that we have plenty of green space, probably 25 to 30% of green space. So that portion doesn't remain an issue. With water quality, just because we're drawing a boundary around the MUD, we don't have a higher or lower regulatory compliance responsibility than with any other development. And the city and county have the availability to place regulations on water quality as well as the state that we would comply with.
Thank you, Ms. Scott.
Thank you.
We'll hear next from protestants. Ms. Rogers, good morning.
Good morning. My name is Emily Rogers, and I represent the cities of Waxahachie and Midlothian and Ellis County. I would like to introduce County Judge Todd Little. He's going to take a few of the minutes of my time to speak to you all.
Thank you. Good morning, Judge. Good to see you, sir.
Good morning, Chairman, and good morning, Commissioners. Oh, Ellis County, 219,000 in population, according to the most recent projections from the North Central Texas Council of Governments. Adjacent to Dallas County, Waxahachie, Texas, you might know by the county seat. 24 MUD district applications currently under petition for this body. Our county is seeing exponential growth rate of 7 to 10% per year in population, somewhere between 12,000 and 20,000 new residents every year. The burdens that each district creates for us as commissioners and county judges: emergency services response, police protection, water quality and groundwater supply, damage to county infrastructure, flood control and drainage impacts, and obviously the impacts of our public school systems and our private school systems that just are having a tough time keeping up with the growth. I can leave the courthouse and be in downtown Dallas at the Big Red courthouse in 30 minutes. Under Local Government Code, Chapter 212, the county has the authority to implement development standards. We've done a very conservative job of doing that, very pro-property owner rights. You can see by the growth that we're seeing in the county. In good faith, the cities of Midlothian, the city of Waxahachie, and Ellis County attempted to mediate this MUD district creation in somewhere around July of 22, maybe August of 22, to no avail. And we did address those concerns in our development standards with this proposed development. So we're here today in protest of the creation of this district. Somewhat of almost 11.
I'm sorry to interrupt, but I need the comments to be confined to the record and things that are already in the record. And I believe some of the comments are not supported by information in the current record. And so I'm going to advise the commissioners not to consider some of the factual information that our speaker was
Okay.
putting forth.
Thank you. I'll conclude my comments. Thank you.
Thank you, Judge. Appreciate your testimony about the burdens of burgeoning MUDs, and it's happening all over the state.
So my clients are concerned about the creations of MUDs in the district, in the county, as it puts a lot of pressure on the counties and the cities. My clients agree with the ALJ's recommendations to deny this application because the applicant failed to demonstrate that the proposed MUD and the subsequent development will not have an unreasonable impact on the water quality and groundwater. A MUD is particularly advantageous to a landowner developer, as it will enhance the value and marketability of the developer's property, and the developer will get reimbursed through the MUD for the cost of the infrastructure. MUDs also have the power to condemn property, levy taxes, enter property, employ law enforcement, in addition to providing water and wastewater services. Conversely, as you've heard from the judge, the development within the MUD can have negative impacts on the surrounding land and natural resources. Thus, in order to balance these competing interests, the Texas legislature adopted Texas Water Code Section 54.021, which lays out what this commission must consider when granting or denying an application for a MUD creation. Texas Water Code 54.021 requires this agency to consider, among other things, whether the district and subsequent development will have an unreasonable effect on several things, including natural runoff rates and drainage, water quality, groundwater levels, recharge, subsidence, and other items. This agency must consider the availability of comparable services. The evaluation of these factors under Section 54.021 should not be based on cursory or conclusory information or on simple acceptance of information in the MUD petition. The review should not be based on estimated, preliminary, or tentative plans for the development. No real analysis can happen based on tentative, preliminary, estimated plans or information. Additionally, this agency shouldn't abdicate its responsibilities under Section 54.021 to other jurisdictions or entities. With respect to water quality, the MUD's application did not address stormwater quality at all. The ED deferred the analysis to local authorities. The uncontroverted evidence, though, shows that there will be an increased runoff of nutrients into the receiving streams that are already barely meeting water quality standards as is. For example, the amount of phosphorus that will be emitted from the non-point sources within the district will be 173% higher after development. The stormwater from the district will also have elevated amounts of ammonia, nitrogen, and other nutrients. The TCEQ's water quality staff prepared a TPDS permit associated with this project that considers these levels to be unreasonable. Without stormwater controls, the phosphorus loading from the stormwater within the district will likely be 75 pounds per day. The proposed TPDS discharge permit only allows 12 pounds per day. Similarly, for ammonia nitrogen, loading from the stormwater within the district will likely be 48 pounds per day. The TPDS permit, though, only allows 12. Neither the applicant nor the ED addressed this issue. Simply deferring to local authorities on this issue is not what is allowed by the statute. Moreover, there was no review of the local regulations to determine if those regulations require stormwater quality controls, and whether those regulations are applicable in the ETJ. And in fact, they are not. There is no local authority that will regulate stormwater quality control. With respect to the groundwater analysis, the application states that the water supply will come from surface water sources. However, the suppliers actually, in fact, primarily rely on groundwater wells to supply water. But the application had no analysis regarding the impacts on groundwater. It simply said surface water will be the source of supply. The cities and county outlined in their closing arguments and exceptions other reasons this application should be denied, and we urge the commission to consider those. For these reasons and the reasons in our closings and our exceptions, the cities and the counties urge this commission to adopt the exceptions to the PFD and deny the applications recommended by the ALJ. I'm available for questions.
Thank you, Ms. Rogers. I have none. Colleagues, any questions for Ms. Rogers? Seeing none. Thank you. All right, let's hear next from Executive Director's staff. Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Bobby Salehi. I'm an attorney in the Environmental Law Division representing the Executive Director. With me today is Justin Tack, the manager of the district section. The Executive Director respectfully recommends that the Commission issue the order for Highland Lakes Municipal Utility District Number 1 of Ellis County, as drafted by the Executive Director, and create the district. The petition complies with all applicable statutory and regulatory requirements. The ED recommends that the Commissioners reject the proposals of the ALJ and her proposal for decision and create Highland Lakes Municipal Utility District Number 1 of Ellis County. Thank you, and we're available for any questions.
Thank you, sir. I have none. Colleagues, any questions? Seeing none. Mr. Martinez, what does the Office of Public Interest Counsel think?
Good morning, Chairman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez, and I am Acting Director for the Office of Public Interest Counsel while Mr. Arthur attends to a family matter. We participated in this hearing, and we have reviewed the PFD in these proceedings, finding that the applicant has not met its burden with regard to potential negative impacts on groundwater and on water quality. As to impacts on groundwater levels, the record contained conflicting evidence about the reliance of Mountain Peak SUD's utilization of groundwater for current production capacity versus that SUD's plan to utilize mostly surface water to serve the development, but also to potentially drill groundwater wells on the applicant's property, which made it difficult to approximate what impacts on groundwater levels could be anticipated from future operations of that water provider, and even more importantly, how much, if any, impacts could be said to be attributable to the proposed district. However, we found the evidence supported a finding that the applicant met its burden to show any impacts on groundwater would not be unreasonable by virtue of the preliminary engineering report indicating that the SUD intended to use mostly groundwater to serve the proposed development. The record did not sufficiently refute this showing by indicating that the development would drive Mountain Peak or Buena Vista SUD's need to specifically utilize groundwater to such an extent that it would generate unreasonable impacts. And for these reasons, we differ from the conclusion of the PFD with respect to that issue. As to negative impacts on water quality, while the applicant did specifically assert that it would construct the development's drainage system in accordance with applicable standards, we acknowledge the PFD's conclusion that the applicant did not cite specific state, county, or city pollution prevention requirements that would lead to effective pollution prevention measures, and that no analysis was done regarding stormwater quality or the anticipated elevations of nitrate, phosphorus, sediment, or other constituents of concern that may promote nuisance vegetation or reduce dissolved oxygen levels. We therefore do not object to the PFD's finding that the applicant's evidence was insufficient on those grounds. For these reasons, we support the PFD's conclusions related to the failure to demonstrate that water quality would not be unreasonably negatively impacted, and its related findings of fact and conclusions of law. Thank you, and we're available for any questions.
Thank you, Mr. Martinez. I have none. Colleagues, any questions? All right, seeing none. Ms. Scott, you have 6 minutes and 10 seconds.
All right, well, I'll try to cram as much as I can into that remaining time. But what I want to really start my rebuttal with is what our threshold is and where the bar is. And so you heard from the protestants some general objections to the creation of the MUD and the, growth within Ellis County and around the city of Waxahachie and around the city of Midlothian. But I would present to you that this is the public policy of the state of Texas and why we have MUDs that exist, because we do have in the state a policy of corporate relocation, of inviting companies and people to come and live in this state. And if they do that, pursuant to our public policy, they do need a place to live. And this is something that's affordable to someone who might be a firefighter, to a school teacher. But that's why the developer, under state law, is permitted to finance the development over time, because it is an advantage to the home buying consumer. And you have also heard that certain studies weren't done, that water quality studies, drainage studies weren't done. That is not required under the law. And if we raise the bar, if we change the threshold of what's required for developers, and they spend $1 million or more, put a number on it. I don't even know what it is, because they're not required to do it at this point. But at the MUD creation process, where all we're doing is drawing a boundary around a landowner's property, and they have to spend that money up front, then the public policy of the state of Texas is defeated, because then they cannot reasonably expect to pass their savings on to the home buying consumer. And at the end of the day, that's the person who's relocating to Texas, who's raising a family, who's trying to buy something affordable for the American dream, and they would be thwarted from doing that. We also heard some argument surrounding the negative impact on the groundwater levels and water quality. Negative is not the issue. The standard under the law is unreasonable, and there was no testimony whatsoever that the Ellis County's regulations were unreasonable, that the city of Midlothian or Waxahachie's water quality standards or this agency's were unreasonable. To continue, what we proposed is more stringent even than what would be required by the city or the county. And we did also hear a little bit of testimony about argument about the TPDS ES permit. That's a separate issue. And again, we'll be approved for that separately than the MUD creation. That's a separate issue. And again, I would point out that if we are going to use any groundwater as opposed to surface water, there are established regulations through the Groundwater Conservation District that overlays our proposed district, and their authority and purpose is to protect the groundwater in the district. Again, I think that's something that you have disposed of previously as being an issue, but if we do, talk further about runoff, that was something that was specifically in the PFD found to be met by the applicant because of the 25 to 30% impervious cover that will be included in the district, and that doesn't just include the open spaces and parks. There's more land within the district that would be impervious and contribute to the water quality that we have the higher standards on. But I would want to go back then to my original argument where I talked about, it's really a stare decisis argument. I mean, as a developer in this state and a landowner, you should be able to rely on what the law is. And what the law is that the commission does review all of the items, but the two that we're here about today are, the groundwater levels and water quality. But the landowner developer should be able to rely on the precedent, of this agency and how the staff evaluates their review. And that's all that's required under the law. When the bar is raised is at the time when bonds are issued. And that's when the staff goes and puts boots on the ground at the development and says, are you in compliance with all of the state and local jurisdictions' rules? And at that point, if they're not, then they don't issue the bonds. But at this point, where we're just drawing a boundary around someone's property, there's no risk of that. It is just allowing the developer to continue to put a affordable product on the ground for Texans that the state has allowed for through the Texas Water Code. And I think that if we're continuing to change the ground rules on that, it's going to make it really hard for developers to achieve that purpose and to provide what they can for Texans. And I'm happy to answer any questions.
Thank you, Ms. Scott. I have no questions. Colleagues, any questions for Ms. Scott?
All right, thank you.
All right, thank you. I do want to compare notes with General Counsel on one thing, colleagues. Colleagues, I've got a rather lengthy analysis because this was a hotly contested item. Feel free to interrupt me at any point, or we can discuss it at the end. Either way, and let me begin with the standard. And I'm repeating some of what's already been laid out this morning, just to get us all on the same page. But the Water Code, and it is section 54.021, instructs us to determine whether the proposed MUD is, quote, feasible and practicable and is necessary and would be a benefit to the land to be included in the district, end quote. And it further provides that that determination include a consideration. Statute, in fact, directs us to consider three factors, and these are: first, the availability of comparable services from other systems. Second, the reasonableness of projected construction costs, tax rates, and water and sewer rates. And finally, whether the proposed MUD, its systems, and subsequent development will have an unreasonable effect with respect to 7 factors. And those factors are land elevation, subsidence, groundwater level within the region, recharge capability of a groundwater source, natural runoff rates and drainage, water quality, and total tax assessments on all land located in the district. And in addition to that, we must determine whether the petitioner has met the other procedural and substantive requirements for a MUD that are laid out at section 54.015, 0.016, and so on, relating to the content of the petition, and importantly to the question about local government consent, city consent.
So those are the standards that we're looking at and what we need to determine. As I said, most of these issues were contested, and let me just dive in with issue A. And this concerns the city's consent and the request for water and wastewater services from the city. And here I agree with the ALJ's analysis and conclusions that the petitioner met its obligation to request consent and to request services. And I believe the city's lack of response to Bay Harbor's request cleared the path for this petition. Turning to issue B1, in determining whether comparable services are already available, the commission considers, I think typically four things. So I'll let it lay out the precedent or authority from previous decisions. The first is that the commission considers other entities with the legal authority to serve an area that's not currently served. We look at other entities' existing infrastructure that's nearby. We look at the costs associated with using other services. And finally, we look at additional terms or conditions or limitations that might be imposed by other entities. And here the petitioner has appropriately partnered with Mountain Peak for water supply. With respect to wastewater, Waxahachie's closest potential connection is a few miles away, and Midlothian's assets are both far away, and it appears likely unavailable without annexation, which would require additional density limitations. So here I would not disturb the ALJ's finding and conclusions on this item. As for the reasonableness of construction costs and tax rates and water and sewer rates, that's issue B2. Again, I agree with the ALJ. I'll just add that the reasonableness, our practice has been to judge the reasonableness of projected costs and rates at the time that the petition is submitted. So we do not require petitioners to supplement their preliminary estimates. Issue B3 is whether there's an unreasonable effect on groundwater levels within the region and on the recharge capability of a groundwater source. The evidence shows that the impervious area is typical of this type of development and adequate such that it will not have an unreasonable effect on groundwater levels or recharge. And colleagues, my opinion is that our analysis should end right there. I think the parties and the ALJ's focus on the use of groundwater in the development's supply is misplaced. The commission does not regulate groundwater. That's subject to the rule of capture or limitations that are imposed by a groundwater conservation district. I don't think the legislature intended TCEQ to regulate groundwater through the creation of MUDs. For example, I don't believe the commission should bar or limit Mountain Peak's ability to develop groundwater sources to which it's otherwise lawfully entitled. And to put it a little bit differently, Mountain Peak's lawful use of groundwater is not relevant to our inquiry. And the same would be true for this or any other petitioner. So on this issue, I would change the ALJ's findings and conclusions to focus on the effect of the impervious area and recharge features, if there are any implicated, and not on the lawful use of groundwater as a source of supply. And colleagues, if you agree, I'm prepared to include those changes in a motion that I can present later. Issue B4, natural runoff rates and drainage. The evidence in the preliminary engineering report is a general description of the infrastructure with future construction assumptions and a representation that the system will comply with local requirements. The protestants argue that there is insufficient detail to meet the petitioner's burden, and we heard quite a bit of discussion about the threshold, what the commission's practice is. We have not, and my thought is that we should not here require the kind of detail that the protestants describe in terms of studies and so forth. So I would not change the ALJ's finding on this issue. Issue B5, effect on water quality.
The point source discharge from wastewater treatment will be addressed in the TIPD's permitting process, and if permitted, will not unreasonably affect water quality. As for non-point source stormwater runoff, the evidence shows that residential development does in fact contribute more nutrient and sediment pollution than does open space. I think that's pretty well established in the record. There's evidence in this record that the effects of this project would be no different from other similar projects. And I couldn't find, colleagues, any evidence that this project will have any greater impact than any other residential development. And the way that I read protestants' argument is that typical anticipated increases in non-point source pollution from residential development as compared to open space is or may be unreasonable. And the ALJ agrees with that, finding insufficient evidence to establish that the development will not have an unreasonable effect on water quality. And colleagues, I'm not eager to go down this path. I'm certainly interested in your thoughts on this issue. I think it's one of the key issues on this PFD. But I think following that line of reasoning, following the ALJ on this, would be a significant departure from our past practice. I think it would have significant practical and policy implications. And so I would put it this way, and I'm expressing an opinion, and perhaps we'll adopt it as a commission, but for now it's just my opinion, and it's as follows. Where there will be nothing more than typical impacts from converting open space to a residential development, and where the applicant represents that it will comply with all applicable stormwater requirements, I believe that that is proof enough that the impacts will not be unreasonable. So that opinion would be dispositive. But I want to mention that I also disagree with the notion that local government requirements pertaining to stormwater conveyances strictly implicate the quantity of runoff. Those conveyances also convey some water quality benefits. And moreover, the applicant's exceptions point to its plans to maintain natural drainage corridors and open space as a means of mitigating water quality impacts. And that's all on the record. So, colleagues, that's my analysis of issue B5. And if you're amenable, I'll offer a motion with corresponding changes to the ALJ's findings and conclusions. Issue B6, total tax assessments. Here the protestants re-argue issue B2, which is the reasonableness of projected construction costs and tax rates. That is partly relevant to this inquiry, but the issue has already been answered. The key question is whether at the time of district creation, upon the district's creation, the aggregate burden will be reasonable. And the evidence, I think, supports the ALJ's finding that the aggregate burden would be reasonable. I do want to add, however, that I think the discussion of future bond rate reviews that's referenced at finding of fact 49 takes the analysis too far. We consider aggregate tax assessments at the time of district creation and should not include future projections. And so I'm going to propose that we strike finding of fact 49. In addition, based on the ALJ's discussion and on conclusion of law number 9, it appears that the ALJ inadvertently omitted the word not from finding of fact 50. So I'll propose that we correct that error to be clear that there will not be an unreasonable effect. All right, we're up to issue C, pertaining to the justification for the creation of the district. This discussion focuses on the requirement that's articulated at 30 Texas Administrative Code 239.11 D5J. But I want to highlight that this rule is a content requirement for the petition. It's a summary or catch-all provision that requires the petition to include justification as appropriate. It uses the term, that's a quote as appropriate. So being a content requirement, I think it's
not a separate analysis, and really the substantive requirement and our central question in considering petitions for the creation of a MUD is found in the statute. And again, that's 54.021. So I would propose that in conclusion of law 14, we cite the statute and not the rule. Issue D concerns landowner signatures. And the operative word, I think, here is when. The statute provides that, quote, when it is proposed to create a district, end quote. And it goes on to say that petition shall be filed and shall be signed by a majority in value of landowners. I think the ALJ was correct to decline the protestant's invitation to consider transfers after the petition was filed, and and was likewise correct to accept the Ellis County Chief Appraiser's affidavit. Turning to the request for additional road powers, issue E. There are 4 content requires that must be satisfied. These are laid out at 30 Texas Administrative Code, section 293.202A. And I agree with the ALJ that the petition meets these requirements. The first, concerning the city's consent, has already been addressed and answered, I believe, by our discussion of issue A. Second, the preliminary layout of roads does not require detail on all roadways. A layout showing major roads is adequate. This is kind of another threshold. Where will the bar be, or where should the bar be kind of issue. The final 2 content requirements, and I think the most important requirements, are to demonstrate the financial and economic feasibility of the proposed improvements. And Table 11 in the preliminary engineering report, as well as the executive director's technical memorandum, provide, I believe, uncontroverted support that these requirements are met. I have no issue with the ALJ's apportionment of transcript costs. And finally, I did find 2 factors that were not contested, and those are the effect on land elevation and subsidence, which perhaps are less relevant in this part of the state. But the record evidence does support a finding that there will be no unreasonable effects. So I would add a new finding, and I would modify conclusion of law number 9 to include elevation and subsidence in the list of issues that have been satisfied. So, colleagues, that is my analysis. I mentioned that I have a motion that I'm prepared to present if y'all are aligned with that analysis. So let me check in with you, see what you think. Commissioner Lindley.
Well, thank you. That was very thorough. You obviously put a whole lot of time and effort into that, and I'm appreciative of it because I don't really have anything to add. I'm in agreement. I appreciate your discussion on B5, I guess, and I tend to agree that as far as surface water is concerned, I don't think there will be an unreasonable effect on water quality, simply because the district is converting open space land into a residential development. But I like the way you said it even better. So I think I will be in complete agreement with your motion, but I'll, take a look at it when I get it or when you read it or whatever you plan to do.
Thank you, Commissioner. Commissioner Janeka.
I'm also receptive to reviewing and voting on that motion that you described. The two closest touch points here, water, the groundwater recharge, groundwater impacts, and water quality. I think you laid out very well how the ALJ's proposal before us today would represent, in my opinion, a departure from agency's past practice, and how we've considered and reviewed these issues. And while I do want to push back on one of the comments today, I think this is far more than just simply drawing a box around property in what we're being asked to do today. This is growing government. This is growing and creating a persistent tax burden on Texans. But I think that the cabin ask that is before our agency and the full reviews that will take place at the appropriate moments when bond issuance, as you described, when consideration of other permitted permits relative to activities around this development. That will preserve the opportunity for the public to engage at that point in time. But for us to do a more extensive analysis or impose obligations in regards to water quality or in regards to sources of water use or where that water might be for these sorts of MUDs, I think those are inappropriate questions to go beyond our past practice. And I just want to recognize this is a very live issue. You alluded to it earlier, Chairman, and I appreciate very sincerely Judge Little coming personally and appearing before us to provide some additional support for the impacts of developments like this on their government. This is a real issue of discussion, and I'm eager to review that lengthier motion, but I'll conclude and just say I'm in agreement.
Thank you, Commissioner. And it is lengthy. You're correct to anticipate that. And just to preview it real quickly, what I intend to do is make changes to certain findings of fact and conclusions of law and ordering provisions, just to be consistent with the discussion, the analysis I just laid out. The motion is also going to memorialize the decision to grant the petition and establish the district and appoint temporary directors and so forth. And I don't want to read it. It spills onto 5 pages. So I'm going to ask Ms. Smith to email a copy to Commissioner Janeka, so you can look at it and then circulate copies, and we'll have hard copies for interested parties at the clerk's desk in just a moment. And I'm going to propose that we take a recess to allow time to digest that. And let's see, I've got 10:48 right now, so why don't we plan to resume at the top of the hour at 11 o'clock, if that works for y'all. All right, we're in agreement. Okay, we'll discuss the motion on the other side, and with that, the time is 10:48, and we are in recess.
yours on here. That's yours.
Folks, it's 11 o'clock. We're going to gavel in here in just a moment. All right, it's 11 o'clock. We're back after a recess. And colleagues, what do you think? Commissioner Lindley?
I'm in agreement with the motion language you sent around, and I'll give Commissioner Janeka a moment, I guess.
I'm also in agreement. Thank you. I'll let you make that motion to consider the circulated motion.
I can do that then. I would move that we adopt the motion circulated today by Chairman Neerman.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you all. Ms. Smith, when you're ready, I'll ask you to please call the next item.
Item number 3 is the consideration of the ALJ's proposal for decision and proposed order assessing administrative penalties against Ranch Hand Apartments LLC. The order of presentation will be the ED, respondent, and then OPIC. Each party will have 5 minutes of oral argument time, and the ED may reserve time for rebuttal as the ED bears the burden of proof.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, Office of Public Interest Counsel. My name is William Hogan. I'm a staff attorney with the Litigation Division, here today representing the Executive Director. I'm here today in support of the Administrative Law Judge's proposal for decision as amended by the Executive Director's exceptions concerning the Executive Director's enforcement action against Respondent Ranch Hand Apartments LLC. There are 3 violations at issue in this case. Respondent failed to provide adequate storage capacity and an adequate number of service pumps for their public water system. They also failed to provide as-built plans and specifications for that system. The ALJ found the Executive Director met its burden in regard to all 3 of these violations. The Executive Director also showed that the administrative penalty proposed for these violations was calculated fairly and in accordance with the TCEQ penalty policy. ALJ found that the Executive Director met its burden in this regard as well. The Executive Director submitted several minor exceptions regarding the proposed order, all of which the ALJ accepted. Accordingly, we would request the Commission adopt the proposed order as amended by the Executive Director's exceptions against the respondent. Thank you, and I'll reserve the remainder of my time for any questions.
Thank you, Mr. Hogan. I have none. Colleagues, any questions? All right, seeing none, let's turn next to the respondent. Mr. Daniel, are you with us, either in the room or virtually? Clearly not in the room. Do we know whether he's made an attempt to register or sign in?
He has not signed in, and my understanding was that he was not planning on signing in.
Okay. Let's move on then and hear from Public Interest Counsel, Mr. Martinez.
Good morning again, Chairman and Commissioners, General Counsel, and Executive Director. We participated in this hearing and support the finding that the respondent has not complied with the public water system requirements at issue in this enforcement action, and that the penalty policy has been appropriately utilized to calculate the recommended penalty. Based on the evidence, that must be our conclusion because it's what the record showed. However, what's less clear from the record, not because it wasn't discussed, but because I feel it was de-emphasized by the judge, is the story the respondent attempted to communicate at the hearing regarding his efforts to find an engineering firm that would develop and seal plans for an existing system, and his trials and tribulations paying for but not receiving work product for a project in which he had no expertise. I've had conversations with respondent during and after this hearing took place. They're not in the record, so I won't discuss them here, but suffice it to say that we have connected him with small business assistance, and that our office generally opines that he has made good faith efforts to comply with what's been asked of him, as that phrase can be understood in ordinary parlance, despite the fact that a good faith reduction under our rules is probably not appropriate here because the violations have not been remediated. We would therefore support a reduction of the penalty as justice may allow in an amount equal to a good faith reduction, though we ultimately do recommend the commission make a finding that the executive director has met its burden in these proceedings. Thank you. I'm available for any questions.
Thank you, Mr. Martinez. I appreciate the careful analysis. Colleagues, I don't have any questions. Do you have any questions?
No, thank you.
Seeing none. All right. Mr. Hogan, I'm not sure you have much to
If I might, Chairman.
Oh, I'm sorry.
I just wanted to thank
Yeah.
you. Thank you. I don't have a question, but I do want to thank Mr. Martinez. I appreciate OPIC's additional recommendation or sharing their position in regards to that matter. I think that's very useful feedback where I appreciate the point you made about where the ALJ did not focus on it, so it's not in the record before us. I sincerely appreciate your that little nugget communicates volumes to me. That was a question that was clear on my mind as I reviewed the record, and I just wanted to say that was a very useful piece of feedback. Thank you.
Thank you, Commissioner. And Mr. Hogan, I was about to say, I don't know that there's much to rebut here, but let me give you that opportunity if you heard anything you want to chime in on.
Yes, sir. I'll just speak briefly on the good faith effort reduction. The executive director would respectfully disagree with the Office of Public Interest Counsel. Under TCEQ's penalty policy, a good faith effort reduction is only available when a respondent has returned a violation to compliance. In this case, respondent has been out of compliance since 2015. In the proposal for decision, ALJ Rodriguez even recognized that respondent is no closer to having a compliance system than it was in 2016. In light of that conclusion, the executive director would urge the commission to adhere to the penalty policy and not reduce the penalty on account of respondent's alleged good faith efforts to comply.
Thank you, Mr. Hogan. Colleagues, I can kind of see some equities on both sides of this case, but I have been talking a lot this morning already, and so I'm going to give you an opportunity, and just based on seniority, Commissioner Lindley, I'll let you have a first bite at it if you like.
Well, yeah, with seniority comes such special privilege, I guess. You know, I don't have a whole lot to say. I did jot down one or two notes, and so I'll kind of stick to them. But, you know, what I would say, I'm going to kind of restate the obvious, right? This item involves an enforcement matter. It's related to a public water supply. They failed to submit plans and the specifications that we require before review and construction can happen. The system doesn't have the storage capacity or service pumps required by our rules. There's no dispute that these violations occurred or that they're ongoing. The only dispute is whether a good faith effort to comply reduction should be applied to the penalty. And I think given that the violations were identified many years ago and they are still ongoing, at this point, when it went to hearing at least, they were still ongoing, I would not apply the reduction. I agree with the ALJ's proposed order with the modifications recommended by the ED and agreed to by the ALJ, and I would adopt those that order with the amendments. So that's kind of where I come down on it.
Thank you, Commissioner. Commissioner Janeka, how do you see it?
I'm in agreement as well. I think the additional input from OPIC was very instructive for my understanding of how much the respondent is in a good faith effort to comply mode right now. Frankly, the matter that brought them before us in 2016 painted a very negative picture in my mind in terms of how much this looks like a respondent who's eagerly trying to find way into compliance, and I think the length of time that has passed is definitely concerning. Acknowledging the efforts that respondents gone to once they're back in compliance certainly would be appropriate in terms of reducing penalties or things at that point. But in terms of what's before us today, I do want to respond to one point that was in the record, though, that the respondent alleged our agency staff had recommended or suggested one particular engineering firm. I think that was how one of the first technical experts that the respondent utilized was described. They described them as someone that we had recommended, and that's not ever something that I've been familiar with or expect to hear from our agency. I'm very familiar with our staff exercising prudence and not falling into a position of advising the public where exactly in matters like this, it comes back and potentially bites us. And so I'm comfortable moving forward today with the ALJ's order as they have before us. I'd be curious to hear your thoughts, Chairman, but little bold of me, I'll move that we adopt the ALJ's proposed order with modifications recommended by the ED's exceptions and agreed to by the ALJ's reply.
Do you have any thoughts or comments?
I don't have anything else to add, but thank you for that.
I would second that motion then, if that was, I think I heard a motion, yeah.
Yeah, I heard a motion.
I would second it.
Anything else before I call a vote? All right. Motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of whether to affirm, modify, or set aside the interim executive director's emergency order appointing a temporary manager of a water utility owned by Linda Royal, Robert Watts, Peggy Parlin, Michael Watts, and Shane Watts. The order of presentation will be ED, then respondents, the temporary manager, and then OPIC. Each party will have 5 minutes for oral argument, and the ED may reserve time for rebuttal as the ED bears the burden of proof.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Benjamin Worms, and I'm an attorney with the Litigation Division representing the Executive Director. With me today is Dorothy Young of the Water Supply Division, and we're joined online by staff of the San Antonio Regional Office. Item number 4 is the emergency order appointing a temporary manager of the utility owned by the estate of Alan Watts. This utility was owned by Alan Watts from 1997 until his death in October of 2021. Mr. Watts died intestate without transferring ownership of the utility, and his estate has not yet been probated. The named respondents in this emergency order are the children of Alan Watts, who are the known heirs to the estate of Alan Watts under Texas intestate succession. At the time of Mr. Watts' death, the utility was being operated by Paul and Linda Royal, and on August 1st, 2022, the Royals sent a letter to staff of the TCEQ, the Public Utility Commission, and the Office of the Attorney General, stating their intent to stop operating the utility on September 1st of 2022. Given this notice from the Royals, the utility was determined to be abandoned, creating substantial risk of imminent water outages and posing health hazards to the customers served by the utility. At the time of the abandonment, the City of Luling agreed to assist in the operation of the utility, and the Executive Director issued an emergency order on September 1st, 2022, appointing the City of Luling's wastewater operator, Mr. Bill Shuley, as a temporary manager for an initial term of 180 days. Mr. Shuley's appointment was renewed on March 1st, 2023, for an additional 180 days. On July 19th of 2023, TCEQ received an application from the City of Luling requesting funding through a supplemental environmental project program to provide long-term service to the customers of the utility. TCEQ is currently engaging with the City of Luling to facilitate provision of safe and continuous water service from the utility and to move the utility into receivership to better serve the customers of the utility. A viable candidate willing to serve as receiver for the utility was not confirmed until July of 2023, and on August 17th, 2023, TCEQ referred the utility to the Office of the Attorney General for the appointment of a receiver. The City of Luling has designated their water superintendent, Mr. Jaime Avalle Sr., to serve as temporary manager. Appointment of a new temporary manager through the issuance of this emergency order was needed to ensure continued operation of the utility and to allow for time for a petition to appoint a receiver to be prepared and for a judge to approve and appoint a receiver. This order appoints a temporary manager for a period of 360 days, as opposed to the 180-day term that temporary managers have historically been appointed for. This longer appointment period is due to legislation passed during the 88th legislative session, which increased the maximum term of an emergency order to appoint a temporary manager for a water utility from 180 days to 360 days. That was effective on September 1st of 2023. The Executive Director respectfully requests that you affirm the September 1st, 2023 emergency order, and we are available to answer any questions you may have.
Thank you, Mr. Warms. I have none. Colleagues, any questions? All right, seeing none, is there anybody here for the respondents?
No one has signed in for the respondents. We didn't expect them to appear.
Okay, Mr. Wayne, what does the Public Interest Counsel's office think?
Hey, yes, thank you. And good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. For the record, I'm Sheldon Wayne for the Office of Public Interest Counsel. OPIC has reviewed this item, and we agree with the Executive Director that the requirements for an emergency order contained in Chapters 5 and 13 of the Texas Water Code have been met, and that issuance of this emergency order was both necessary and appropriate. As we sit here now, this is, of course, the third emergency order issued for this utility, and OPIC observes that the issues with the water system look to be working their way towards resolution. We recognize that TCEQ has taken substantial steps to identify a long-term management solution, including engagement with the City of Luling and referral of the utility to the Office of Attorney Generals for appointment of a receiver. As such, OPIC supports affirmation of the September 1st, 2023 emergency order. Additionally, we would like to take a moment to voice our appreciation for the services and work that Mr. Bill Scholl provided this utility, and we further would like to thank Mr. Ovalle Sr. for agreeing to come on as temporary manager during the interim. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. I have none. Any questions, colleagues? Seeing none. Mr. Warms, did you hear anything you wanted to rebut?
I did not.
Okay, thank you, sir. Well, colleagues, I'll just add my thanks to Mr. Schul, again, for his service, and to the City of Luling for jumping in with us and helping to solve this problem. I think this is my first opportunity to thank Mr. Ovalle for his willingness to take this assignment. We really appreciate it. I don't foresee any controversy on this one, colleagues, so I'm just going to go ahead and move that we affirm the interim executive director's emergency order appointing a temporary manager of the water utility located at 114 Salt Lake Road, Luling, Guadalupe County, and that we issue the executive director's proposed commission order.
A second.
Any discussion? All right. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the application by Megatel Homes LLC for new TIPD's permit number WQ00161620001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Chapter 55 of our rules provides a two-part analysis for considering requests for contested cases on TIPD's applications. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case, and assuming that at least one requester has done so, we then consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. Governmental entities can also establish standing if, in addition to those factors, they identify statutory authority over or interest in the issues relevant to the application. And colleagues, on this item, we have a pair of requests, both on behalf of the City of Mansfield. I agree with the Executive Director's Office and the Office of Public Interest Counsel that the city has met all of the procedural and substantive requirements to be entitled to a hearing. The proposed facility is within the city's ETJ and close to its corporate limits. The city has unique authority or interest not common to the general public
relating to the provision of wastewater services and to public safety, as well as surface water quality. Speculation that the proposed service area might opt out of the ETJ in the future does not change the fact that the city is currently an affected person. So I would grant the requests and refer the matter to SOA on the following issues. 1, whether the draft permit should be altered or denied based on the consideration of need or our policy to promote regionalization, as those are articulated in the water code. Issue number 2, whether the draft permit is protective of water quality and the existing uses of the receiving waters. Commissioner Lindley, what do you think?
I'm in complete agreement on the 2 issues and the city of Mansfield.
Commissioner Janeka?
Likewise.
I will move then. I would
Please.
move that we grant the hearing request of the city of Mansfield, that we refer the application to SOA for a contested case hearing on the following 2 issues. Issue 1, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code Section 26.0282 and the general policy to promote regional or area-wide systems under Texas Water Code Section 26.081. And issue 2, whether the draft permit is protective of water quality and the existing issues in the receiving waters under the applicable service water quality standards in 30 TAC Chapter 307, and that we set the hearing duration of 180 days from the day of the preliminary hearing until the proposal for decision is issued.
And before, I just wanted to make sure I heard you correctly, that on issue 2, whether the draft permit is protective of water quality in the existing uses.
Uses in the receiving waters.
I thought I heard issues, but
I might have said issues, but I meant
wanted to
uses for my
clarify.
motion. Thank you.
Okay, yeah.
I second that clarified motion.
All right, the motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 6 is the application by Camden Park Municipal Utility District of Rockwall for new TIPD's permit number WQ 001-603-6001 to authorize the treatment and discharge of domestic wastewater. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, the legal standard is identical in this one as to how we analyze requests for contested cases on TIPD's applications. We first consider who's entitled to a hearing and then which issues are referable. We have 2 requests on this item. The first is by David and Karen Milan, whose property is within roughly 900 feet of the proposed facility, with the discharge route running through their property. Their request raises concerns about nuisance odors, water contamination, the impacts to health, livestock, and wildlife, among others. And although the proposed discharge is relatively small, it is clear to me that the Milans have demonstrated interests that differ from the general public. And having met the other procedural and substantive requirements, I would grant their request. The North Texas Municipal Water District, a governmental entity established by the legislature to serve regional water and wastewater needs in the region north and east of Dallas, owns infrastructure very near the proposed facility. That district's request raises regionalization concerns, so I agree with the executive director and OPIC that the district is affected in a manner different from the general public, has raised relevant concerns, and met the other requirements to be entitled to a contested case. Turning to the issues, I would refer the following: whether the draft permit is protective of the requesters and their families' health, whether it is protective of wildlife, livestock, and the environment, whether it adequately protects against nuisance odors, and whether it should be altered or denied based on the policy of regionalization. And that's it. Just those issues. Commissioner Lindley.
I'm in agreement on all that.
Likewise, and I move that we grant the hearing requests of North Texas Municipal Water District and David and Karen Milan, that we deny remaining hearing requests and all requests for reconsideration, that we refer the matter to the TCEQ's Alternative Dispute Resolution Program to run concurrently with SOA preliminary hearing scheduling efforts, that we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is protective of the requesters and their families' health, wildlife, livestock, and the environment in accordance with applicable regulations, including the Texas Surface Water Quality Standards. B, whether the draft permit adequately protects against nuisance odors in accordance with 30 Texas Administrative Code, Section 309.13. And C, whether the draft permit should be altered or denied based on the Commission's regionalization policy pursuant to Texas Water Code Sections 26.081A and 26.0282. And finally move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second.
The motion has been made and seconded. All those in favor say aye.
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 Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 7 is the consideration of the petition filed by Samuel Sparkman Brindley Trust for the creation of Johnson County Municipal Utility District Number 1. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Colleagues, as you know, requests for contested cases on MUD creation petitions are governed by Chapter 55 of our rules, which requires the commission to grant the requests of affected persons, and that is a person who's filed a timely hearing request that identifies a personal justiciable interest not common to the general public, and that identifies the requester's location relative to the activity that is the subject of the application. We're still in Chapter 55, but a little bit different from TIPTE's applications. House Bill 801 does not apply here. So we simply identify affected parties and refer them without needing to identify particular issues that have been preserved. We have 2 requests on this item. The first is from the city of Mansfield. I believe the city has met the procedural and substantive requirements to be entitled to a contested case. The city filed a timely request. The proposed MUD is entirely within the city's ETJ, and the city identifies interests that are not common to members of the general public and are relevant to the Commission's jurisdiction on petitions to create MUDs. These include the city's interest in providing water and wastewater services and in impacts to water quality and groundwater levels or recharge. And as I mentioned in connection with item 5, I believe that the pending application to exclude the proposed district's area from the city's ETJ is immaterial. The second requester, the Johnson County Special Utility Districts, holds a CCN that entitles it to be the sole provider of water services for areas that include the entirety of the proposed district. The utility district is in my view, pretty clearly affected in a manner different from the general public by virtue of its CCN. Its interest is relevant to the Commission's jurisdiction on MUD petitions, and I believe it's met the other procedural and substantive requirements to be entitled to a hearing. So I would refer both requests to SOA.
I agree.
Likewise.
We're ready for a motion.
Yeah, I would move that we grant the hearing request of the City of Mansfield and Johnson County Special Utility District and refer the matter to SOA for a contested case hearing on the petition.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, please call the next item.
Item number 8 is the consideration of the petition filed by Cipriana Island Laguna Azure LLC for the creation of Johnson County Municipal Utility District Number 2. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So, colleagues, this item is a companion item to number 7, in that these MUDs would be adjacent and part of the same development. This time we just have a single request by the city of Mansfield. I believe the analysis on the city's request here is identical to what I laid out on the last item. And unless you see a distinction, I would vote in favor of referring the city to SOA for a hearing.
I agree.
Mm-hmm. Likewise, I move that we grant the hearing request of the City of Mansfield and refer the matter to SOA for a contested case hearing on the petition.
I second.
The motion has been made and seconded. All those in favor say aye.
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 Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 9 is the application for the creation of Williamson County Municipal Utility District number 38. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right, colleagues, it's Mud Week here at TCQ.
These guys aren't getting a break.
Yeah. Yeah, and I don't see it letting up. We have before us yet another petition for creation, and this one also includes a request for additional road powers. And in this case, we have 3 requests for a contested case hearing. And just for completeness, I'm going to repeat those requirements. Requests for contested cases on MUD petitions are governed by Chapter 55 of our rules. Those rules require the commission to grant the requests of affected persons. An affected person is one who has filed a timely hearing request that identifies a personal justiciable interest not common to members of the general public, and that identifies the requester's location relative to the activity that is the subject of the application. Justiciable, in this case, means interests that are relevant to the commission's jurisdiction on petitions to create a MUD. And colleagues, all 3 requests, the concern that's expressed about the proposed MUD are the impacts coming from a wastewater treatment plant or project. However, the MUD petition indicates that there will be none, but rather that wastewater will be disposed of through individual septic systems owned and operated by homeowners. And accordingly, I believe the requesters have not raised a personal interest that's affected by the application, the creation petition here. So I would deny the request and consider the petition on its merits. Proceeding with that analysis, let me repeat the standard again, and forgive the redundancy, but the Water Code, and again, we're back with section 54.021, instructs us to determine whether the proposed MUD is, quote, feasible and practicable and is necessary and would be a benefit to the land to be included in the district, end quote. In making that determination, the statute directs us to consider 3 factors. These are the availability of comparable services from other systems, the reasonableness of projected construction costs, tax rates, and water and sewer rates, and whether the proposed MUD, its systems, and subsequent development will have an unreasonable effect with respect to 7 factors: land elevation, subsidence, groundwater level within the region, recharge capability of a groundwater source, natural runoff rates and drainage, water quality, and finally, total tax assessments on all land located in the district. In addition, we must determine whether the petitioner met the procedural and substantive requirements for a MUD petition, such as the request for city consent and the petition content requirements. So let's turn to the evidence. We have both the petition and the executive director's technical memorandum detailing the staff's review of the petition. The memorandum in particular demonstrates that the proposed MUD is feasible and practicable and is necessary and would be a benefit to the land to be included in the district, considering the 3 factors and 7 sub-factors described in the statute. The memorandum also demonstrates that the petition meets the other applicable requirements and that the criteria for additional road powers are satisfied. So, colleagues, I think we should grant this petition, approve the road powers, and appoint directors.
I'm in agreement.
Likewise.
I think we're ready for a motion.
I'll give one a whirl. I would move that we deny all hearing requests, that we grant the petition for creation of Williamson County Municipal Utility District Number 38, that we find the petition satisfies all applicable statutory and regulatory requirements, and the district is feasible, practicable, and necessary, and would be a benefit to the land to be included in the district, that we approve the district's request for road powers in accordance with Texas Water Code Section 54.234, and that we appoint the 5 following people to serve as temporary directors until permanent directors are elected and qualified. Mr. Timothy Noble, Mr. Travis Hansen, Ms. Amanda Santos, Mr. Eric Lara, and Ms. Lori Renegar. And that's the end of my motion.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 10 is the consideration of gifts and donations of $500 or more in value given to the TCEQ and submitted for approval in accordance with Chapter 575 of the Government Code. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Amy Mendez of the General Law Division representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. I'm available to answer any questions you may have concerning these items.
Thank you. I have none. Any questions, colleagues? Ms. Smith, has anybody signed in to speak?
No one has signed in.
Mr. Martinez.
Good morning again. OPIC supports approval and issuance of the resolution acknowledging the Executive Director's acceptance of gifts and donations in accordance with Chapter 575 of the Government Code.
Thank you, colleagues. I appreciate these gifts. I want to thank the donors. Commissioner Emily Lindley.
I'm good.
Okay. Commissioner Janeka.
I'm as well. Thank you. I'm as well. I move that we approve issuance of the resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCEQ Interoffice Memorandum to the Commissioners dated October 6, 2023, identified as docket number 2023-1227-MIS.
I second.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which is items 11 through 18. The Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me are Amy Sedemeyer and Michael Parrish, also of the Enforcement Division, and Anna Treadwell of the Litigation Division representing the Executive Director. Pending before you are items 11 through 18. The total assessed administrative penalties are $208,325, with $39,735 deferred, $38,850 applied towards supplemental environmental projects, and $129,740 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
No.
All right. Seeing none. Has anybody signed in to speak?
So on 11 and 18, we have individuals who have signed in and indicated that they're available for questions. And then on item 14, we have Mr. William Brotherton who would like to address the commission. I believe he's virtual.
Mr. Brotherton? Okay. Mr. Brotherton, are you with us?
I am.
The floor is yours. Go ahead when you're ready, sir. And I'll just ask you to state your name at the top of your comments for the record.
Yes, my name is William Brotherton. I'm sorry. I went to the dentist yesterday, and I thought it was going to be a simple crown, and instead it was multiple injections of Novocaine. So I'm representing Joseph Gaber, who operates Cody's Market, and we've agreed to the order, but I wanted to make the commission aware that Mr. Gaber suffers from lymphomic cancer, and the issues with the measuring the tanks was that he was gone into the hospital and his family had taken control of the store for him, and apparently they didn't do things right. There are no spills. There's no issues whatsoever except for paper compliance. And he is in full compliance now, and I would ask that the fine be waived in its entirety. He's made a good faith effort to work with the TCEQ, and I'm available for any questions.
Thank you, Mr. Brotherton, and we're certainly sorry to hear about Mr. Gaber's health issues, and we'll respond to that request in just a moment. But let me check first to see if there's anybody else who is signed in to speak. Ms. Smith.
No one else is signed in.
Okay, and sir, I want to come back to the executive director, staff, and to the Office of Public Interest, and to my colleagues on your requests in just a moment. But Mr. Martinez, let's go ahead and gather OPIC's thoughts on the whole of the docket, and then you can share any additional thoughts you may have in connection with item 14.
Yes, sir. We have reviewed these items, their proposed penalties, any comments submitted by the respondents, compliance histories, adherence to the penalty policy, notice and other procedural requirements, and at this time, we're satisfied these items do in fact comply with the relevant statutes, rules, and policies of the Commission, and OPIC is therefore prepared to support adoption of the proposed enforcement orders listed in items 11 through 18 of today's Commission agenda. As to item 14 and the comments that were just proffered, we would welcome the Commission to take into account any mitigating factors that might have interfered with the ability to comply with paperwork requirements.
Thank you, Mr. Martinez. Let me turn it back over to Executive Director staff to respond to what you heard on item 14.
In regards to the status of compliance, we are still anticipating that the respondent would be providing us or the agency with a release determination report. And my understanding is that the respondent has been working with our remediation division, and so we were anticipating that would continue. So we can't recognize compliance at this point.
Okay. Thank you, Ms. Cordell. Colleagues, your thoughts? Commissioner Lindley.
I think we should probably just move forward, with adopting the items as they're proposed, 11 through 18. That's tough to say, but I think with what's before us today and what's in the record, that's the right path we should take, to just go with what's been proposed what's been recommended by the executive director.
Thank you, Commissioner. Commissioner Janeka.
I think I'm comfortable going either way. I appreciate Commissioner Lindley's recommendation to move forward with the items as we have today. I'm also comfortable remanding the item to the executive director, and perhaps this item 14 could come back after remediation's work has concluded and they're back into compliance. But I'm certainly will defer to you, Chairman. Let you cast the tie vote on that one.
All right, thank you, Commissioner Janeka. And again, I'm really sorry to hear about Mr. Graber's health issues. It's a difficult situation. Commissioner Lindley, I think I do agree with you. We have an agreed order before us. There are payments that have been scheduled out over 35 months. So I appreciate that this is a burden. I think the agency has done everything it can to work with and accommodate that burden, and agree that we should probably go forward with this suite of orders, including item 14.
I can make a motion then, I guess, and anyway, I will move that we adopt items 11 through 18 as recommended today by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 19 is the consideration of the monthly enforcement report, and the executive director's staff is here to present this item.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Amy Stedemeyer and Michael Parrish of the Enforcement Division, and Anna Treadwell of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2023 through August. There are 1,023 effective administrative orders issued, and of those, 144 contain supplemental environmental projects. These orders assessed a total of $13,963,289 in penalties, with a payable amount of $8,424,234. $3,592,533 are to be paid towards supplemental environmental projects. 14,740 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 2,137 enforcement action referrals have been received. There are 2,452 pending administrative orders, with 1,273 cases on the backlog. 176 cases are pending at the Attorney General's office for representation in district court, and 19 judgments have been issued. 2,109 cases are being tracked for compliance. We've included for review a summary of OCE investigative activities for fiscal years 2021, 22, and 23. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions? All right. Ms. Smith, is anybody signed in to speak?
No one is signed in.
Mr. Martinez.
Good morning again. Eli Martinez with the Office of Public Interest Counsel. We have no comments on the report, but we as always appreciate the efforts by the Office of Compliance and Enforcement to ensure that the limits and protections of our issued permits and other authorizations are properly adhered to.
I feel the same way. Thank you for the report. Colleagues, no action is necessary on this item. So, Ms. Smith, I'll ask you to please call the next items.
The next items are for closed session, and the commission will meet in closed session in room 4222, building F, at approximately, let's say, 12:10, as permitted by the Open Meetings Act, including Texas Government Code sections 551.071 and 551.074, to take up and consider matters pursuant to item numbers 20 through 23 as posted and noticed.
The time is 11:48 a.m. We are in recess.
The commission met in room 4222 in Building F for closed session from 12:05 until 1:21 p.m. on item numbers 20, 21, and 23 as posted in notice pursuant to Texas Government Code Section 551.074. No action was taken. This agenda stands adjourned and the time is 1:30.